Hello there, my name is Brandon Joe Williams, and I'm a trustee of Williams & Williams Law Group. You can find us at www.williamsandwilliamslawfirm.com. There's a page on there that I've done that's quite extensive, and I'm going to be showing you in less than 10 minutes how to get rid of your driver's license, how to not pay taxes ever again, etc. It's called A Treatise on the Word Person. And the last time I updated it here, you can see, was 7/9/25. And if you want more information, I also have, you'll see in this important notes section, if you come on the website, there's also a link to a live demonstration of a live talk of me talking about a lot of this information. But this is just going to be a 10-minute video, so we're only going to be able to cover some of the most important points. So if you want to get a full breakdown of everything, please go to williamsandwilliamslawfirm.com and click on A Treatise on the Word Person. With that said, the first thing we need to figure out is we need to talk about this case called Dred Scott versus Sanford, right? Because I'm going to prove to you there's two types of citizenship, and one of them is where you want to be, but that's not where you are. And that's what we're going to get to with this, right? So in Dred Scott versus Sanford, we have the fifth Chief Justice of the Supreme Court. His name is Roger B. Taney. And here's a photo of your boy, Roger B. Taney. This is the guy who's going to be giving this opinion we're going to talk about here right now. So in relation to Dred Scott, who was an emancipated slave, right, he's talking about here the words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through the representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. And he says here, the question before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of this sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. So you can see what Mr. Taney's talking about. We have the preamble of the U.S. Constitution. The very beginning of it is, we the people of the United States, in order to form a more perfect union, establish justice, blah, 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 blah. We the people. Then we have in Article 1, Section 9, Clause 1, this is talking about restrictions on the slave trade. This comes from the Constitution, by the way. The migration or importation of such persons. People say Roger B. Taney was this big racist guy, and it was the worst, Dred Scott versus Sanford was the worst case that's ever happened in the entire history of the United States. Roger B. Taney had already gotten rid of all of his inherited slaves, so he is not racist, he's just going based off the Constitution. So that case really, had a big stink to it, because we were already moving into the Civil War because of the whole slavery versus anti-slavery, North versus South. So after that point, obviously at that point, we have all the slaves at that point in time, and any of them that may have been emancipated or let go couldn't get citizenship, period, end of story. That was Dred Scott versus Sanford, right? So we move into the Civil War, and we're coming out of the Civil War, and now we have this new case trying to address the Dred Scott versus Sanford decision. It's called the Slaughterhouse Cases. And this was this case finalized, and the final opinion was given on April 14th, 1873. And the final opinion was given by a man named Samuel Freeman Miller. Here's your boy, Samuel Freeman Miller. Samuel Freeman Miller had been working, he taught himself law while he was practicing medicine as a doctor, and he worked for, many, many years to get into the Supreme Court, and then he was in the Supreme Court for somewhere around, 10, 11 years before the slaughterhouse cases had actually happened. And he felt very strongly about freeing the slaves and had for a long time. So it makes sense that he was the one who was chosen to give the final opinion in the slaughterhouse cases, which we'll talk about right now. So Mr. Miller says, then all the, which I'm not going to say that word, you can read that one because I'll get TikToked, whatever, race who had recently been made free men were still not only not citizens, but were incapable of becoming so by anything short of an amendment to the Constitution. To remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States and also citizenship of a state, the first clause of the first section was framed. What are you talking about? First clause of the first section? He's talking about the first clause of the first section of the 14th Amendment. All persons, not people, persons, born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, blah, 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 blah. What are they talking about? Not white people. Continuing on in Slaughterhouse, the first observation we have to make on this clause is that it puts at rest both the questions which we stated to have been the subject of differences of opinion. It declares that persons may be citizens of the United States without regard to their citizenship of a particular state, and it overturns the Dred Scott decision by making all persons born in the United States and subject to its jurisdiction citizens of the United States. Here's an important part. That its main purpose was to establish the citizenship of the beep can admit of no doubt. The phrase subject to its jurisdiction, I'm not going to get into that. That's a little bit, you can read that if you want, but that just explains that next part of the first clause. Then he goes on to say, it is that the distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter, right? And then he goes on and on and on. It is quite clear then that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other and which depend upon different characteristics in the individual. This is crystal clear in a California Supreme Court case, Allen v. Valkenburg versus Albert Brown. No white person born within the limits of the United States and subject to their jurisdiction, or born without those limits and subsequently naturalized under their laws, owes the status of citizenship to the recent amendments to the federal Constitution. The history and aim of the 14th Amendment is well known, and the purpose had in view in its adoption well understood. That purpose was to confer the status of citizenship upon a numerous, and then it goes on and on and on, class of persons who, talking about the release, slaves, basically. And you can look more about that and read that on this page if you want to see the rest of the quote. So basically, now we got this whole thing figured out. There's this U.S. citizen class, and then there's a state citizen. State citizen is for white people. U.S. citizen was originally for the slaves of a certain color, which won't be said. And then, that kind of thing, right? So it's pretty racist in its most basic idea, right? So if we look at a W-9 tax form, this is most of the time what you guys are filing when you go to get a job. You're signing under penalty of perjury, which is up to 1 year in prison, by the way. It is a felony. I am a U.S. citizen or other U.S. person defined below. Let's go take a look. So scrolling down on the W-9, we have here definition of a U.S. person. Number one, an individual who is a U.S. citizen or U.S. resident alien. So a U.S. citizen essentially is somebody whose citizenship lies with the District of Columbia, and it was specifically for the original slaves, and it's not for white people. And a U.S. resident alien is somebody who's not a U.S. citizen or a state citizen. They're here basically just residing as a foreigner. They have foreign allegiance, like a Brazilian or something like that. That would be a U.S. resident alien. Other things that this term U.S. person could include would be a partnership, corporation, company, or association created or organized in the United States or under the laws of the United States, an estate other than a foreign estate, a domestic trust. So as you can see, the bottom line on all this is you can't have a driver's license. You have to be a U.S. citizen or a resident. You have to prove residency to get a driver's license. And you can't pay taxes because you have to say under penalty of perjury that you're a U.S. citizen or a resident alien in order to pay taxes. So for me, for example, as a white California citizen, if I filed a W-9 tax or if I filed any taxes, I'd go to prison. And if I had a driver's license, I'd be going to prison. Pretty wild. If you'd like to see more information, please go to williamsandwilliamslawfirm.com. Check out a treatise on the word person, And I hope you guys like this, and I'll see you later.